Let's go. Let's go.
I'm going to have the attorneys clear out some of the exhibits so that we have more room. And so we're going to take a recess for about 15 minutes so we can bring those exhibits together. I'm sure you understand. All right, so we'll see you back here in about 15, 20 minutes.
That's right, Dr. L is gone. He's at home today sleeping, not
the
thinking
Simpson matter.
about OJ.
Mr. Simpson is again present before the court with his counsel. People are represented. And I see we have Mr. Darden, Mr. Gordon, and Mr. Wooden with us today. All right, good afternoon, gentlemen.
Sugar, I forgot to watch.
All right, Mr. Darden, are you going to present the next witness?
Yes, Your Honor.
Are you prepared to proceed?
Yes.
All right. Deputy Mayor Nairn.
I had one job. That was to watch this video, and if the glove comes out, I was supposed to hype it up. Guys, I'm working on something big right now, and it's taking my soul. I mean, my time. That's why I missed this. I don't know what I was thinking. If this is the glove, I'm going to cut it, not the glove, the clip, and post it as a video for everybody else to see later. But you'll get to see it first. Here, you earned it. Let's go.
May we have the jurors, please? Right next to the court reporter, please. Raise your right hand, face the clerk.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat and will you stand and state and swear your first and last names for the record.
Brenda Vemich.
Can we have your spelling, please?
V as in Victor, E-M-I-C-H.
Thank you.
Mr. Darden.
Thank you, Your Honor. Good afternoon, Ms. Vimich.
Sigourney
Ms.
Weaver.
Vimich, who are you employed by?
Bloomingdale's.
And what is your position with Bloomingdale's?
I'm a buyer for men's dress shirts.
Men's dress shirts?
Yes.
And were you employed by Bloomingdale's on December 18, 1990?
Yes.
And what was your position then?
I was the men gloves buyer.
You were the men's glove buyer. During December of 1990, did Bloomingdale's have a relationship with Eris Isotoner?
Yes.
And did Bloomingdale's sell Eris Isotoner gloves?
Yes.
Can you tell us whether or not there was a line of gloves sold exclusively by Bloomingdale's, that is, gloves that were manufactured by Eris Isotoner?
Yes.
And can you tell us the name or the style of those gloves?
Well, we bought many gloves from Eris, but there was one particularly important glove, and it was called an Eris leather.
Sustain. Rephrase the question, please.
Okay. Did Bloomingdale's sell more than one type of glove, that is, more than one exclusive type of Eris Isotoner glove?
Yes.
Are you familiar with the glove called Eris Isotoner Thin?
I don't understand the question.
Okay. Are you familiar with the glove that goes by the style number of 70263?
Yes, that is an Eris leather light glove that was an exclusive glove for Bloomingdale's.
Okay. And this Eris leather Eris leather light glove was manufactured by Eris Isotoner?
Yes.
Okay. And you were in charge of purchasing gloves for the men's section?
Yes.
Were you selling that particular type of glove on December 18, 1990?
Yes.
Okay. And in which department in the store could those gloves be purchased?
In the seasonal glove department, seasonal accessories. Seasonal accessories.
And if you know, what was the retail price of those gloves?
Those particular gloves were $55.
And what was the selling price on December 18, 1990, if you know?
They were $55, but during December 18th, they were marked down at 30% off.
Could you describe style number 70263, the Eris Isotoner leather light glove?
Yes, this particular glove has many characteristics that are very distinctive to this type of glove. One of the first characteristics is the leather. The leather is extremely lightweight, almost paper thin, and that was one characteristic. The second was the stitching. The stitching of this glove was called a brosser stitch, which is a very refined whip stitch.
How do you spell that? Rosser.
I believe it's B-R-O-S-S-I-E-R.
Thank you. Got it.
So the stitching was very unique as well.
Okay. Any other unique characteristics?
Yes, the vent palm was on the palm side of the glove. The V that is in the glove is in the palm side. So that was another characteristic.
Okay. Now, was there a lining to these gloves?
Yes, they were cashmere lined. So all four of these characteristics combined together made this glove a very unique and special glove.
During the recess, you were here in court this afternoon, is that correct?
Yes,
And at that time, were you asked to view two gloves in particular?
yes,
By the way, have you ever visited any factories where gloves are manufactured?
yes, many times throughout my career in accessories.
And have you tried several pairs of gloves on?
Yes, many, many, many pair.
Okay, in your professional capacity? And that was in your professional capacity?
Yes.
Where can we do this, Your Honor?
Where would you like to do it, Mr. Darden? You want to do it here on the shelf in front of the witness?
Okay.
Mr. Wooden, do you want to just pull off a sheet of paper and fold it up to that side, please?
Ms. Bimich, given the description you provided us of the Aris isotoner leather light already, are you able to identify that glove when you see it?
Yes.
Let me show you the glove that has been marked. People's 164A. It is LAPD item number 9, the Rockingham glove. Showing you People's 164A. Looking at that glove, can you tell us whether or not that glove is an Aris isotoner leather light glove?
Can you turn it off? Yes, this is an Aris leather light glove.
Does this glove have the V indentation in the palm area that you described earlier?
Yes, the vent palm.
Okay, how about the stitching?
The stitching is the brosser stitching. The lining is cashmere.
And does the leather appear to be particularly light as you described earlier?
Very thin for a glove, yes.
And this glove, the glove exclusive to Bloomingdale's?
Yes.
By the way, when you looked at these gloves during the recess, was Mr. Cochran present?
Yes.
And Mr. Shapiro?
Yes.
Okay, and myself and Mr. Wooden?
Yes.
What was it, seven? I'm showing you the glove that has been marked Exhibit 77. People 77.
Can you turn it off, please? Yes, this is an Aris leather light glove.
Ms. Bemich, if you know, how many pairs of these gloves did Bloomingdale's purchase during 1990?
Bloomingdale's purchased approximately 1,000 dozen, which would be about 12,000 pair.
And what is the color of the two gloves you just saw?
The color's brown.
And what is the size?
Size is extra large.
During 1990, how many pairs of Aris isotoner leather light gloves, brown in color, size extra large, did Bloomingdale's purchase?
Approximately 300.
300 pair?
Yes.
Now, when you say that these gloves were exclusive to Bloomingdale's, what exactly does that mean?
That means that these gloves were designed and developed for only Bloomingdale's, and were sold nowhere else.
Okay. Have you ever seen these gloves sold anywhere else in the United States?
No, I have not these gloves.
Okay. Have you traveled abroad to Europe and Asia?
Yes.
Have you ever seen these gloves in Europe or Asia?
No, I have not.
Is there a Bloomingdale's in Los Angeles?
No, sir.
Where is the Bloomingdale's that is the one closest to Los Angeles?
The closest one, I believe, is in the North Michigan area, in the Chicago store. It's the closest.
The Chicago store is the closest?
Yes.
Now, did you purchase these same gloves for Bloomingdale's during 1991?
No, I did not. I inherited this particular buy, the first buy.
Okay. Were pairs or several pairs sold to Bloomingdale's during 1991?
Yes.
How about 1992?
Yes.
Okay. 93?
Yes.
You purchased the same gloves that I've just shown you, or the same style, during 1993?
The manufacturer started changing some of the...
Sustained. Mr. Darden, ask a question, please.
At some point, did the manufacturer start to change the style of glove that I've shown you here in court today?
Yes.
Okay. What year was that?
1993.
Okay. Did they change the style number in 1993?
No, they did not. They only changed the stitching.
Okay. And so the 1993 model of the Aris Isotoner Leather Light, how is it different from the gloves, if at all, that are here in court
Maybe
today?
I did it.
The stitching, the Brosser stitching was changed. They changed it to what is called a piqué stitch.
And the gloves I've shown you here in court today are not gloves having a K stitch.
No, that is a Brosser stitch.
Now, give me your position as a buyer for Bloomingdale's. Are you in a management position?
Yes.
Okay. And have you been trained in how to ring up credit card purchases?
I've been trained how to buy and merchandise and develop, and occasionally I sell the merchandise myself.
Okay, and so you have received cash register training then?
At one point in time, we have received training, but that is not my primary function. But it's important for me to be on the floor to see what we sold. So I spent a great deal of time waiting on customers and working with them. And specifically, one of the areas that I spend the most amount of time is in the glove area.
On December 18, 1990, was the merchandise in the men's department barcoded at all?
No,
Okay, so you couldn't just sweep it across the device and ring up the purchase automatically?
no.
Okay. How was information, that is the sales information, placed into the computer or sales register?
It was entered in manually.
The next in order is People's 372.
People's 372.
I've shown Mr. Cochran you want to see the original copy of the next exhibit. It is entitled Bloomingdale's Glove Purchase. All right. Moriyama.
In the glove area. She's an expert
There's a
witness
monitor
of
there to
gloves.
your right. Looking at the item marked People's 372 for identification, can you tell us what that item is? The item depicted there?
Well, this is a Bloomingdale's receipt,
Okay.
but it's a little bit blurred here.
Okay. Now I have a second item. It appears to be a microfiche copy of the same receipt. Can it be marked, what if you make a 372B and the item on the AMO 372A?
All right. So, Mark.
Showing you what is it marked 372B. Is that a Bloomingdale's credit card sales receipt?
Yes,
Okay. And is that apparently a copy of what you see there on the monitor?
yes, it is.
Now, looking at that receipt, there are several numbers on it. Is that correct?
Yes,
Can you interpret those numbers for us?
yes. The 517 represents the department number seasonal accessories.
Okay, let me stop you there. Okay, that's to the left of the sales receipt. Is that correct?
Yes,
Okay. 517 indicates men's accessories seasonal department.
yes,
Okay. Now, do you see the number 222034 at the top upper left?
yes.
Okay. What is that number?
That's the employee's ID number.
And whose employee ID number is that, if you know?
It's Helena Phibbs, employee's number.
Okay. And is Helena Phipps here in the courthouse this afternoon?
No. She's here, but not in this room.
Okay. She's in the building.
Courthouse, yes.
Okay. Okay, thank you. Okay. And to go down, to the right of the 517, we see the numbers 55.
Yes.
What do those numbers indicate?
That is the classification number, and 55 represents a glove classification.
So that indicates that gloves were purchased?
Yes.
Okay. And to the right of the 55 is the number 953.
Yes.
Okay. What does that number indicate?
That is the vendor number, and in this case, it is Eris isotoner.
And so based on those three numbers, then you can tell us that there was a purchase in the men's accessories department?
Seasonal.
Gloves were purchased,
Yes.
and that they were Eris gloves?
Yes.
And to the right of the
Probably
953,
sales went up,
we see the number
most likely.
70268. What is that number?
That is the style number of the glove.
And we'll come back to that. And to the right of the 70268, we see the number 2. What does that indicate?
The quantity that were purchased is two gloves.
2 pairs of Eris gloves?
Yes.
And to the right of the 2, we see the number $77.
Yes, that's the retail for the 2 pair of gloves.
Okay. And to the right of the $77, we see the number 30. Is that correct?
Yes, and that is 30% off.
So that means then the 2 pairs of gloves were purchased for 30% off at $77?
Yes.
Can you tell us what the
They doubled
regular
it that-
price of the gloves
The
was?
regular price of gloves of this style is $55.
How many pairs of gloves or types of gloves did you sell at $55 during December 1990?
From this vendor, Eris, there,
Oh, well,
Go ahead.
she's holding the exhibit. She's holding the exhibit. Let's see. Let's try it.
How many different types of Eris gloves did you sell at $55 during
there was
December
only
1990?
one Eris glove that I sold at $55.
And what style number was that?
70263.
And
I gotta
which glove?
go, guys.
The style number 70263.
I'll be
Eris
back
leather
real
lined
soon.
glove.
Be good.
So the gloves I showed you in court today then fit the descriptions given on the sales receipt?
Yes.
Okay. Now, the style number on the sales receipt indicates 70268. Is that correct?
Yes.
Did Bloomingdale's ever sell an Eris glove style number 70268?
No, they did not.
To borrow a phrase, is that a mistake?
Yes.
Does that mistake, we'll strike that. The mistake is that the 8 should have been a 3, is that right?
Yes, it is.
Sustained.
Okay, what is, okay, thank you, Your Honor. What is the mistake?
The last digit should be a 3, not an 8.
Has Bloomingdale's ever purchased Eris glove style number 70268?
No.
Do you know whether or not Eris style number 70268 has ever been sold in the United States?
Not that I don't know.
I have one moment, Your Honor.
Sir.
Does the sales receipt indicate the size of the glove?
No, it does not.
Does it indicate the color of the glove?
No, it does not.
Is there any way for you to tell us that the 2 gloves I showed you here in court were purchased during the transaction shown here in People's 372A?
No.
Now, is there a date on that transaction record?
Yes, the date is December 18th.
If we could go down to the bottom of the document. Mr. Fairlawn. Now, at the bottom and to the right of the document, do you see some numbers beginning with 3713?
Yes.
And what are those numbers?
It appears to be an American Express number.
And is there a signature on the credit card receipt?
Yes.
Can you read that signature to us?
Nicole Brown.
Thank you, that's all I have.
Mr. Cochran?
Thank you. Good afternoon, Ms. Flemish.
Hello.
How are you?
Good.
Good afternoon, ladies and gentlemen. Now, as I understand your testimony, Ms. Flemish, what you told us is that if we look at this Bloomingdale's glove purchase receipt there, you can't tell us the color of the gloves purchased. Is that right?
That's right.
You can't tell us the size of the gloves purchased. Is that correct?
Correct.
And as I understand from looking at the receipt, this purchase of 2 pair of gloves was made on December 18th of 1990. Is that correct? That's your understanding?
Yes.
And further, if we are to look at the style number of these gloves, 70268 there. If I can make it, Jonathan, can you use the 70268, please? That style number, 70268, you're telling us that that was not a style number that Bloomingdale purchased from Eris Isotoner in 1990. Is that what you're indicating?
I'm indicating that that is not a style number that existed at Bloomingdale's ever.
All right, well, let me ask you this. Is this number 70268, is that a style number that existed with Eris Isotoner in 1990?
Not that I know of.
Have you done any checking in that regard?
I've inquired.
All right, and who did you inquire of?
I called Eris Isotoner to see if that number existed.
And where did you call?
I called the New York office.
And who did you know the name of the person that you spoke with, ma'am?
At the time, Steph Fogelson.
Steph Fogelson?
Yes.
And do you have a report from Steph Fogelson?
No, not really. He was not sure.
You know how to spell Steph Fogelson for our court reporter?
Fogelson.
How do you spell the first name?
Steph, Steph.
Thank you.
And what was the time of that conversation with Steph Fogelson, ma'am?
Was the time when I was shown a receipt at Bloomingdale's and when I started to inquire what the merchandise was. The 70266, my record showed 70263. This was 70268. I had no record of 70268, so I called the resource and asked him if it ever existed.
Can you get back to my question now? What was the date that you called Mr. Fogelson?
Probably sometime in January
Of what year?
of this year.
So January of 1995, you called him, and you found out, did you not, that the style number 70268 did in fact exist with Eris Isotoner gloves, and in fact it had been assigned to a customer named Herring. Isn't that correct?
No.
Sustain.
Well,
Could you repeat the question?
let me rephrase the question.
Please.
Take that. Did you find out in the course of your conversation, first of all, that Eris Isotoner did in fact have a style number of 70268? That was a style number that they produced.
Sustain.
I still don't understand the question.
Well, you don't have to answer, right?
When there's an objection and I sustain the objection, you don't have to answer the question.
Thank you.
All right. The purpose, as I understand your call, was to find out about other style numbers produced by Eris Isotoner. Is that correct?
Yes.
And you had a conversation with Mr. Steph Fogelson in which you inquired as to whether or not there were other style numbers produced by Eris Isotoner, specifically whether or not there was a 70268 style number produced. Did you not?
Yeah.
Can you answer that yes or no?
Oh, you can answer that question yes or no.
Yes.
And you asked that question, didn't you?
I asked the question,
All right, just
yes.
say yes or no. All right. Did you get an answer to that question?
No, I did not.
Did you get anything in writing with regard to that question?
No, I did not.
Prior to your testifying here today, have you ever seen a report from a Mr. Fogelson who purports to be the general manager of Eris Isotoner Gloves and Knits Department?
No.
You've never seen such a report?
No.
Have you ever heard the name Herring before? H-E-R-I-N-G.
No.
Now, with regard to this purchase back on December 18th of 1990, you at that time were a buyer for Bloomingdale's, is that correct?
Yes.
You were not the salesperson in this transaction, is that correct?
No.
And you didn't see who may have purchased this 2 pair of gloves on that particular evening or that day?
No.
From the number of the employee, you know it was somebody by the name of Phipps who basically weighed on this particular customer? Is that correct?
Yes.
And have you talked to Ms. Phipps?
Yes.
She's in this building
Yes.
today?
Yes.
You talked to her today, I presume?
Yes.
You've also talked to Mr. Rubin today also?
Yes.
Now, with regard to this transaction that we should start and ask you some questions about, as I understand it, there's nothing on this particular sales slip that tells us this is an Eris isotoner glove, is it?
Yes, the vendor number tells that it's an Eris,
Yes.
and the style number and the price, $55, tells me that it is an Eris Leatherlight glove.
All right, but then when you look at the style number, that is a style number that was not a style number assigned to Bloomingdale's. Isn't that correct?
All except the last number.
I'm asking, is that number, it is not a number that was assigned to Bloomingdale's, was it?
It was not a number that was assigned to Bloomingdale's.
Right. And as Mr. Darden pointed out, that's a mistake, you believe?
Yes, I do.
But you were not present at the time of this purchase, is that correct?
No, I was not.
And what you've been asked to do is to look at some records that are now approximately 4.5 years old, is that correct?
Yes.
And to try and interpret them for us, is that correct?
Yes.
Now, these particular gloves that were shown to you during the break, was that the first time that you'd seen these particular gloves?
No.
When had you seen them before?
In January.
And where did you see them at that time?
I saw them, I believe, at the evidence place.
At the police department?
Yes.
That was you came out here. Do you live in California?
No, I live in New York.
All right. So you came out here from New York and you looked at the gloves at that time?
Yes.
So when we saw these during the recess today, was that the second time that you'd seen them?
Yes.
And who, may I ask, was present at the time you saw them in January?
Phil Van Etter,
Detective Van Eyck? Anyone else?
Detective Lang.
All right. Anyone else?
There could have been someone else, but I didn't know the name.
All right. Those are the only ones you can recall at this point?
Yes.
And you didn't make any reports or anything regarding that particular visit, did you?
No.
And I think we've established that you can't tell from this receipt either the color or the size of these particular gloves. Is that correct?
From the receipt?
Yeah.
No.
Now, with regard to the gloves, and if we might just see the gloves, Your Honor.
Which one do you want me to check?
Let's start with that glove.
I think Mr. Cochran's going to have to change his glove.
Yes, Your Honor. We've certainly made everybody more sensitive about gloves around here. And I'll be glad to.
The witness put another piece of clean paper on the shelf before the witness.
Thank you, Your Honor. They're both in here. I put them.
You may.
For the record, Your Honor, I'm taking People's Exhibit number 9 for identification out, and I'm going to place this before the witness.
Actually, that's LAPD item number 9. That's People's 164A.
Thank you. Item 9, yes. Now, this is this particular glove that I placed here is one of the items that you saw back in January. Is that correct?
Yes.
And this is one of the items that you saw here in court today. Is that correct?
Yes.
And if we look inside this particular item, it has some kind of a lining, and is that cashmere lining as far as you know?
Yes.
And in this particular glove, which I guess is the right glove, there are no markings in this glove that came from the factory, are there?
No.
There are no markings that came from the factory, is that correct?
No.
All right. The writing inside this glove was placed by someone at a later time, is that correct?
Yes.
This is a brown glove, is that correct?
Yes.
And can you tell the size of this glove?
Yes,
I'm
it
looking at it.
appears to be an extra large glove.
Matt, try this on you. Supposed to be an extra large glove?
Yes.
Are these gloves, do they come, where are they made?
They're made in the Philippines.
Do they come, are they extra large, just kind of small?
No, but they stretch.
I see. So this is a normal extra large glove, is that correct?
Yes.
But you're saying they stretch?
Yes, but that doesn't fit you.
No, it's too small.
It's too big.
It seems to be, since I'm wearing it, it seems too small for me, but we won't argue about that. You're saying, excuse me.
Mr. Wood?
I believe this purports to be the left-handed glove you are.
That's People 77.
77. And this People 77, if you know, is that to appear to be at least similar to the other glove that you saw back in January of 1995?
Yes.
I presume that you did not put your initials on either of those gloves at that time, is that correct?
My initials?
Yes, you didn't put your initials on either glove, did you?
No.
All right. You were just present with Detectives Van Adder and Lang at the time that these gloves were displayed to you, is that correct there?
Yes.
And at the time, when you saw Detectives Van Adder and Lang handle these gloves at that time, were they using any kind of paper like this?
Yes.
Were they using any gloves, if you recall?
Absolutely.
You recall that, do you?
Yes, because I touched the gloves, and I had to use the latex gloves and the butcher paper, and
this particular glove has a label inside of it, is that correct?
yes.
And the label says Eris, is that correct?
Yes.
And it says cashmere line,
Yes.
and it says made in Philippines,
Yes.
and it says extra large, is that correct?
Yes.
Is there any other, is there a particular lot or style number in either of these gloves indicating this is a 70263 glove?
No, not that I know of.
What, you want to take a look?
I already looked.
So, is it in there?
Not to the visible eye, no.
All right, well, not the visible eye?
Right.
All right, did you use anything other than the visible eye to try to determine that?
That's what I used.
All right, so that's what you used?
Yes.
And you did not see anything that indicated 70263, did you?
No, I did not.
Did you see anything that indicated 70268?
No.
Did you ever have a conversation with Detective Van Adder in which you discussed the subject of whether or not Detective Van Adder ever spoke with Mr. Steph Fogelson? Well,
I don't know if he had a conversation with Steph Fogelson.
that wasn't the question. Did you ever have a conversation with him wherein you discussed whether or not he'd ever talked to Mr. Fogelson?
No.
And is this is supposedly also an extra large glove?
Yes, it is.
Now, prior to coming here to testify today, have you had occasion to watch these proceedings on television?
I work, so only the answer is not too much,
Well,
except on the news.
all right, of course, let's get back to my question. Have you watched these proceedings on television?
Sometimes, yes.
And that was during the course of this past year, is that correct?
Yes.
When did you receive your subpoena and were advised that you to testify in this matter?
I didn't receive a subpoena.
You were told that you were going to testify at some point, however?
Yes.
When was that?
Yesterday, Tuesday at 4:30.
Well, you live in New York, right?
Yes.
And you were told Tuesday at 4:30. Were you out here when you were told that?
No.
You're still in New York?
Yes.
And when you came out here in January, did you suspect you might be testifying in this matter?
I wasn't sure.
But you were told that you were a potential witness, is that correct?
Yes.
And you were called yesterday and told to come to testify, is that correct?
Today's Thursday? Tuesday. I was
Tuesday,
called.
rather. Tuesday you were told. And then you came to California yesterday.
Yes.
And did you talk with the district attorney's office or representatives there before you testified today?
Yes.
Who'd you talk with?
Patty Joe Fairbanks.
And who else?
Chris Darden.
Mr. Darden here?
Yes.
Did you talk with Mr. Darden back in January of this year?
No, I did not.
Now, was your testimony that Bloomingdale sold 300 pairs of extra large Eris isotoner gloves, brown? Was that back in 1990? That's oh. Is that correct?
I was asked how many pairs were purchased in brown,
All right.
and I said approximately 300 were purchased in brown.
Were purchased by customers, is that correct?
No, purchased for Bloomingdale's to sell.
All right, purchased to sell to customers, is that correct?
Correct.
And over what period of time were these 300 pairs purchased by Bloomingdale's?
Between October and December,
Of what year?
90.
All right, so between the period October to December 1990, Bloomingdale's purchased 300 pairs of Eris isotoner brown gloves, is that correct?
Extra large.
All right. Are you aware that the original order by Bloomingdale of Eris light gloves was approximately 6,000 pairs?
The original order for Eris leather lights were 12,000 pair.
All right, well, let's talk about that. It wasn't 6,000 pairs, it was 12,000?
The purchase was approximately 10 to 12,000 pair,
All right, which was it, 10 or 12?
between 10 and 12.
All right, and when was that original order?
For October delivery.
All right, so we could expect then they received somewhere between 10 or 12,000 pairs of these Eris light gloves shortly after the order and for October of 1990. Is that correct?
Yes.
And what you're telling us is that during the period between October and the end of the year, let's strike that. Of that number, 300 were of the extra large brown variety, is that correct?
Yes.
Do you know how many you sold during that period of the 300 pairs that were brown extra large?
Approximately 200 were sold.
200 of the 300. And how do you know that?
It's about a 65% sell-through, and that is a average normal sell-through for gloves during a fall season.
All right. So are you giving us your estimate, or are there some records you referred to prior to coming to California?
I'm giving you an estimate or an approximation of what I believe sold.
Okay. So have you, let me ask you this, have you had occasion to go and actually check what was sold between October and December of 1990 regarding these gloves?
I don't have documentation that proves that.
Okay, I understand. What you then have given this jury is your best estimate of what would happen in a sale over Christmas time and in the fall, is that correct?
Yes, on this particular glove.
And this is garnered over your experience, is that correct?
Yes.
All right. So it could have been more or it could have been less, is that correct?
Could have been.
All right. But you don't have any records to back that up, do you?
I have records that back up that approximately 65% sell-through on leather gloves or gloves during a fall season is a very good estimate.
Right, I understand that, but you don't have any records to say the exact number, do you, ma'am?
No, I do not.
Okay, so we'll accept the fact that about 65% you believe could have been sold during this period, is that correct?
Yes.
That's how you arrive at the number of 200? Is
Yes.
that correct? All right. Now, if you know, are there any knockoffs of these gloves that are sold at least back in 1990 or produced?
Not that I know of because of the distinct characteristics.
So you're not aware of any knockoffs, right?
No, I'm not.
And with regard to the two gloves that I put before you, you can't tell by looking at those gloves whether they're actually an actual pair, can you?
They appear to be a pair.
They look similar, don't they?
They sure do.
But there's no way you can tell whether those are the same, those gloves were purchased at the same time,
No.
can you?
No.
You can't do that, can you?
No.
In your business, have you had occasion to do any investigations regarding so-called knockoffs of these kinds of gloves?
Sure, as a buyer, I think that it's very important to be aware of what's going on in the marketplace. So, yes, I study, I go to competition, I go to stores, I get the opportunity to see every single glove manufacturer, I go into factories, etc. And I have not seen a knockoff of these gloves.
All right. Now, with regard to the barcoding of this particular number, barcoding is a procedure by which you would swipe the glove through some kind of electronic procedure and you would actually get the number up. Is that correct?
Yes.
And as I understand your testimony, in December of 1990, when Ms. Phipps made this particular purchase, you did not have barcoding at Bloomingdale's, is that right?
Not at that time, no.
So that the style number that Mr. Fairlow would be kind enough to put up there for us was manually entered, is that correct?
Yes.
And hence we got this number 70268, is that correct?
Yes.
Have you checked the other numbers that were on that particular receipt?
Yes.
For accuracy. You've done that?
Yes.
Do any of your receipts or any of the receipts you had back at that time spell out either the color or the size of a particular item at all?
No, they do not.
With regard to the prices of gloves back in December of 1990, I presume that Bloomingdale's sold a number of different kinds of gloves at that time. Is that correct?
Yes.
And were there other gloves that were of the same price or the same discount accorded during December of 1990 as Eris isotoner?
Not at the same price.
There were no other gloves in which the discount rate would be 30%?
No.
At that time, you sure about that? Do you have records to that effect?
No, but I remember very clearly because I spent a great deal of time on the selling floor selling gloves personally myself. I was very involved on each style and understanding what made it sell, what made it not sell. And I know that there were no other gloves at $55 specifically from Eris.
And that was back in 1990, you remember that and you know that?
Yes, I remember that.
Were there any other gloves other than Eris gloves that sold for that approximate price? $55. Back in December of 1990.
I don't recall.
That's what I'm asking you. I wasn't just talking about Eris, I was talking about any gloves.
Okay.
In Bloomingdale's in December of 1990. Were there others? Or can you not tell us?
I can't recall.
All right. Just a second, Your Honor.
Certainly.
Now, these gloves were ordered from Eris. Were they shipped to Bloomingdale's in October, or were they shipped in August, if you know?
They were shipped in the fall season. They were shipped on several different orders. Depending on how the manufacturer shipped, they came into our warehouse approximately October through the beginning of December.
These particular gloves retail for what, $18 and $19?
These gloves retail for $55.
I mean, they wholesale for $18 or $19,
They're about $20.
and they retail for about $55. Is
$55.
that right? It's a nice markup, isn't it? Just curiosity.
No
That's
comment.
They were 30% off.
All right. Nice, but that was only at Christmas time, right? All right. Very well. Thank you. I've done it for the on this one.
All right, disregarding any further questions from Ms. Bemich.
Ms. Bemich, important letter from upstairs, Your Honor. Ms. Bemich, what was it about those gloves that made them sell?
I think she's an expert.
These gloves were extremely lightweight. The reason they sold, from my experience in waiting on customers, is that they were almost like a second skin. You could pick up a penny or a needle practically with them, and they were very, again, they're very, very thin. And many people like that about these gloves. And that's why they were called leather lights, and that's why we marketed them leather lights, and it was a big seller. It was a big part of my business.
And you told us that approximately 200 pairs of those gloves in size extra large and in a brown color sold during the Christmas season, 1990?
Yes, approximately 200 pair.
Okay. I neglected to ask you when the receipt was on the screen where that particular purchase was made.
In the 59th Street store.
In New York City?
Yes.
Okay. Are you aware the defendant has a home in New York City?
Sustained. Sustained.
Okay. You don't know how,
Again, sustained.
and you don't know how those gloves made it here to Los Angeles, do you?
No.
Okay. Or to Bundy.
No.
Overruled.
You don't know how one of those gloves found their way to Bundy.
No.
Overruled.
Do Eris isotoner gloves usually have a style number imprinted somewhere on the glove?
Not that I know of.
But you mentioned a moment ago that there was no style number that you could see with the naked eye.
No, there is no style number that you can see.
Are you suggesting that there is some type of number, identification number somewhere on the glove?
I believe there's some kind of identification on the glove underneath the lining that may tell you the lot number or whatever, in what sequence they were made. I'm not an expert in this area.
Okay. And when you identified the two gloves shown to you by Mr. Cochran and myself, was that identification based on the sales receipt or was it based on your observations of the gloves?
The observation of the gloves.
You know that style when you see it.
I know that style.
Now, is there a particular way that gloves are supposed to fit on a man's hands?
They say fit like a...
How are they supposed to fit, Ms. Bemich?
supposed to fit like a glove. They're supposed to fit tight. They're supposed to fit tight and snug, and they stretch, and they're not supposed to be baggy.
Okay. As they were on Mr. Cochran's hand.
That's right.
Okay.
Sustained. Sustained.
Did the gloves appear baggy when Mr. Cochran? If we could just put the sales receipt back up for just one moment. It's 372A. Ms. Bemich, assuming that there was no style number, that is no 70268 or 70263 on the sales receipt, could you still tell us the make, style, model, and price of the glove sold on December 18, 1990?
Yes, because it says that it is a leather glove. It is said it's made by vendor Eris. It was $55. Two were purchased at $55, $110, and 30% off is $77. And I only had one glove from Eris at $55.
Okay, and so $77 is 30% of $110?
Yes.
I think it's 70%.
We never give markdowns.
Certainly.
And if we could go down to the bottom of the receipt again. Come. Okay, you see the name Nicole Brown written there on the receipt?
Yes.
Okay. Are customers required to sign their names when they receive the merchandise and upon the purchase?
Yes.
Okay. And is that apparently what Nicole Brown did in this situation?
Yes.
Thank you.
Mr. Cochran, anything further?
Couple of questions, just regarding these gloves, let's finish. These gloves are sold only for men, is that correct?
Yes.
These are not unisex gloves, are they?
No.
Would you agree that the person who was wearing a pair of gloves could best determine whether or not those gloves were fitting appropriately? Is that kind of a personal thing?
Sure.
Because as a buyer, the customer's always right, isn't he?
Sure.
So if the customer told you those gloves were too small for him, you'd accept that, wouldn't you?
If you wanted to buy them, I would not.
You wouldn't
Tell
quarrel,
you
would you?
no.
All right.
I'd give my opinion.
All right, well, thank you. Now, with regard to the actual numbers of gloves sold, I believe you told us that your general estimate would be that approximately 200 of the 300 pairs were sold during this particular fall period, right?
I said 300 were purchased approximately in
Yes.
brown extra large, and about 200 were sold.
Yes, that's what I said. 200 were sold, right? And would the other 100 then be sold at a later time, or what would happen?
They would be returned to the vendor.
All right. And you have no records as to what number was actually returned to the vendor?
No.
Okay. And with regard to the receipt that Mr. Darden just placed up there again, with regard to how you're able to identify any of the information, it boils down to the correct inputting by Ms. Phipps as to those various numbers. Isn't that correct?
Yes.
Right. So if she was wrong about some other number about the vendor, and if she was wrong about the style number, that would affect what you're telling us. Isn't that correct, ma'am?
It wasn't only the style number that made me believe that this was an Eris Leather Light. It was all the other combinations. It was the class number, and it was the retail number.
Okay, let me get back to my question. My question was if she was wrong about other numbers entered there manually, as she
Yeah.
was with the style number, that would affect the information that you're giving us here today. Isn't that correct, ma'am?
Yes, it could have.
That's right. And that's one of the reasons why Bloomingdale's and other modern stores have now gone to the barcoding effect. So you take out the aspect of human error. Is that correct?
Sure.
All right. Thank you very kindly.
Mr. Darden, anything further?
So that the record is clear, 200 pairs of extra large brown Eris isotoner
Were sold.
were sold during that Christmas season. And when men buy gloves, do they tend to exaggerate the size of their hands when they
Oh,
do they tend to exaggerate the size of their hands when they purchase gloves?
No, she's an expert in glove sales.
Usually women buy gloves for men.
Do they exaggerate the size of a man's hand when they buy them?
Is that a serious question, Mr. Darden?
Yeah.
All right. Do you have many returns from customers with gloves? For resizing?
A few. Not an inordinate amount, a few.
The gloves you showed you today, they are definitely exclusive to Bloomingdale's, correct?
They are exclusive to Bloomingdale's, yes.
All right, Ms. Vemich, thank you very much. You're excused. All right, Madam Court Reporter, would this be a good time to switch reporters? All right, we'll take a 10-minute recess to switch court reporters, and remember my admonitions to you. All right, we'll take a 10-minute recess to switch court reporters.
size, 2 being a 3-digit number, which indicated the individual who actually cut the gloves, and then another 2-digit number indicating the sequence in which they were made from the leather that was given to the cutter at a given point in time. But I don't know if those numbers exist in there right now.
All right, you haven't seen those numbers with regards to the gloves before you, have you?
No.
And at no place has there ever been a lot number or style number like 70263 therein. Is that correct? That was not part of the procedure, was
No,
it?
it was not part of the procedure.
Now, as I understand it, there are Eris isotoner gloves all over the United States. Is that correct?
That's correct.
And all over the world, for that matter. Is that correct?
That's correct.
Are they Bloomingdale's is a store exclusive to the United States? Are they?
I believe their retail operations are. They may have some mail order internationally. I'm not 100% sure.
So back from the 10-year period, 82 to 92, would it have been possible through Bloomingdale's mail order catalog to order these particular gloves during that time frame?
At some points in time, this particular product was in various Bloomingdale's catalogs.
So you could be in France and order those. Is that correct?
If you were on the mailing list, it's a possibility.
Now, do you have any kind of a breakdown of the difference in colors? Let's assume that in 1990 you ordered 10,000 pairs of these Eris light gloves. Do you know how many different colors did you have at that time?
At that time, I believe we had 4 colors: black, brown, gray, and a medium brown.
And do you know the breakdown of the 10,000, how they were ordered?
60% plus would be black, approximately 30% or 28% would be brown, and then the other colors would really be just 10% or so.
There would be much less, is that correct?
Yes.
And would that remain fairly consistent over the 10-year period that you were involved with the company, and at the time these gloves were the same style?
No. Actually, the mix of black to brown gravitated dramatically more toward black as we went farther into the 80s.
More toward black and away from brown?
Yes.
Earlier it had been brown more than black?
No, it was never more, but at one time it was 50-50.
All right, and that was based upon the sales trends, is that correct?
Consumer demand.
Yeah, sales trends, the way
Yes.
people purchased them, is that right?
Yes.
All right. Now, with regard to the gloves that you were shown by Mr. Darden a short time ago, in looking at those gloves, they appear similar to you, do they not?
Yes, they do.
But you can't say they're the exact same gloves were sold at the same time, can you?
What I was looking at when we looked at the gloves earlier was the grain of the leather. The way these gloves were manufactured, just looking at them in this condition, they appear to be a pair that was cut out of approximately half of a skin. And that's what I was looking at. They appear to be a pair.
But in looking at them, you can't tell us for sure they're from the same particular lot, can you? You can't say they're the same, can you?
It's difficult.
All right. There's no individual characteristics that would allow you to make that particular goal. You can say they look similar, right?
They do look similar.
All right, and
That's all I can say.
All right, I appreciate that. And to you, they appear in your color scheme are, what color is that glove? And do you have the left glove or the right glove?
This is the right.
The right glove. What color is that right glove?
This is brown.
All right. And there's no way to look at that particular glove before you now, and you can't tell us, I presume, whether that particular glove was purchased in 1982, 83, 84, all the way up to 92, can you?
I cannot determine the exact date of purchase.
All right. So in other words, what you can tell us is that that particular glove that you believe is the style that was exclusive to Bloomingdale's was or could have been purchased at any time between the time frame 1982 to 1992 when they changed the stitching, right?
Correct.
Is that a fair statement?
Yes, it is.
May I have just a second, Your Honor?
Certainly.
Starting in 1982, were these gloves made starting then in the Eris Philippines factory?
Yes, they were.
And would that be correct then in assuming that for the 10-year period we've been talking about, from 82 till about 92, that all the gloves, whatever numbers, from 1,200 pairs to 10,000 pairs, would have all been made in that factory in the Philippines?
I would only commit up until 1990 for myself.
Because you left.
Yes.
All right. There's no reason to believe they went to some other factory after you left.
I'm not aware of any other factory that could make this product. But I wasn't there, so I can only commit up to 1990.
But you can commit from 82 till 1990, the time you left, that all those gloves were made at the Eris Philippine factory. Is that correct?
That's correct.
And the other styles that they made, there were other styles made for other parts of the world, as I understand. Is that correct?
That's correct.
Did you ever talk to a customer by the name of Herring, H-E-R-I-N-G? Did you ever talk to him personally?
Not personally.
Is that the customer whose style number was 70268?
That's what documentation that I've seen indicates.
And that's the customer whose buyer you spoke with, is that correct?
It was really the sales agent in England that, the style was developed for a sales agent, and then the sales agent, I believe, showed it to the customer and eventually ended up getting an order for that particular style number.
And the customer's name is here.
Yes.
Thank you.
Mr. Darden?
It's a little bit, Your Honor. So the documentation you've seen, sir, indicates that 70268 was never sold in the United States?
That's correct.
Mr. Cochran asked you some questions about the percentage of gloves sold that would be black in color and those that would be brown in color, as well as other colors. But in 1990, assuming you had 10,000 pairs of these gloves, what percentage of those gloves would be brown?
30%.
And what percentage of that 30% would be size extra large?
8%. No, I'm sorry, 8% of the total, not 8% of the 30.
Okay. 8% of the total number of gloves would be extra large?
Right.
But what percentage of the total would be extra large in size and brown in color?
I'm not sure if I understand the question.
Okay. Well, if you had 10,000 pairs of Aris isotoner leather light gloves.
On a 10,000 unit basis, there would be approximately 300 units in extra large brown, totally available.
And of those 300 units, you would expect to receive back into your factory approximately 100 pairs?
It could be that high.
So in your view, then, Mr. Rubin, approximately 200 pairs of brown extra large Aris isotoner leather lights would have been sold during 1990?
Rephrase the question.
In your opinion, how many size extra large brown in color Aris isotoner leather light gloves would have been sold by Bloomingdale's during 1990?
Between 200 and 240 pair.
And did I hear you correctly? Did you testify that the lot sold to Bloomingdale's during 1990 was the largest lot?
Largest lot of this particular style?
Yes. Yes.
Within the mix of what Bloomingdale's purchased, this was the largest lot.
Okay. Okay, well, how many did you sell to Bloomingdale's during 1990?
Of this particular style?
Yes.
When I left, what was on order to be shipped was approximately 12,000 pair. However, these orders were set up to be delivered on an ongoing basis, starting at the end of July, going through the middle of November. Based upon the actual performance of business during the October-November timeframe, I am not 100% sure that they took in all of the pairs that they committed to.
Okay. At any event, the maximum number of brown extra larges that would have been sold during 1990 is 200 to 240, correct?
That's correct.
And in 1982, the first year that these gloves were manufactured apparently and sold to Bloomingdale's, correct?
That's correct.
What would the maximum number of brown extra large, let's strike that. How many pairs of brown extra large Aris leather lights would have been sold in 1992?
There may have been 50 pair in brown, extra large.
How about 93?
Twice as much?
I'm sorry, 83, twice as much?
Yes.
Okay. About 100?
Yeah.
Okay. How many size extra large, brown in color, Aris leather light gloves would you say were sold through Bloomingdale's from 1982?
In 1982?
From 1982 through 1990?
I really would be speculating at this point. I'd have to actually start to calculate what the progression was and then factor in the consumer demand shifting from 50% black and brown and then shifting more toward black. If I had a guess in total,
Okay. Okay.
Ask another question.
Okay. But as the years went on, the color brown in size extra large became more rare. Is that correct?
yes.
Okay. Have you seen the sales receipt from Bloomingdale's for a pair of Aris gloves?
Yes.
I've just been handed another exhibit. Can I confer with Mr. Cochran for a minute?
forward, please. Back into the jury room. This will probably only take about 10 minutes. See.
I have here in my hand what appears to be a pair of leather gloves. There was a tag attached. The tag reads Eris Leathers by Isotoner, extra large, cashmere line. Selling price of $55 by Bloomingdale's. And they be marked 372C.
372C.
Marked 372C. Are those Eris Isotoner gloves?
They're Aris gloves, but these are
The
not
customers
Aris
never
Lights
write,
gloves
ever.
that were like the ones we're talking about from 1982 until 1990.
When were those gloves manufactured, if you know?
These gloves?
Yes.
Only because of what I've learned recently, I was given the impression that starting in 1992, they changed the actual sewing configuration to a different type of construction, but still used the same connotation that was an Aris Lights glove.
Are those gloves cashmere line?
Yes, they are.
Looking at those gloves and the two gloves that you've seen here in court today, can you tell us whether or not they're the same size?
Same size?
Yes.
They're tagged the same size.
Okay. They appear to be the same size.
They appear to be the same size. They were supposed to be the same size.
Okay.
If I had to speculate, though, actually I wouldn't speculate. I could tell you that this particular pair would actually fit tighter than this pair because of the sewing construction.
Okay. Are they both made of leather? That is, the pair in your hand as well as the glove on the bench there?
They're made from leather, but they're not the same leather by any means.
Okay. A moment, Your Honor. You can't tell us whether or not those new gloves will... We'll strike that. Have you noticed Mr. Simpson's hands at all?
I actually haven't.
You can't tell us whether or not either of these three gloves will fit his hand?
I would venture to say that almost every glove that was manufactured by Aris Philippines from size medium through extra large would get on his hand. Some might be tight, some might be loose, but they would get on his hand.
Thank you, that's all.
I think I have to ask some questions this here.
You're welcome. Mr. Darden? All right. Why don't you collect the new exemplars from Mr. Rubin, please? Mr. Darden, you want to collect the exemplar from 374C, 372C. I take it you're not going to use that in front of the jury?
Well, Your Honor,
Probably not.
probably not.
All right, let's have the jurors, please.
Before the jury returns, however, we'd like to have Mr. Simpson try on the original evidence items.
Mr. Carson, any comment?
The only problem is that I would want you have to have gloves on under it. I mean, I don't try to glove on without the rubber gloves and knees, make it look used. And I really like the approach I have with it. Sorry, I like the
Sure. All right, don't go away, Ms. Rubin.
I'm not fast forwarding this. I'm watching this. Sidebar, if the camera goes off this slime ball first. What Cochran said, I think, or Bailey. Hold on, it's important, so I'm going to pause it. I can't remember which lawyer it was on the defense team. It was either Cochran or Bailey. What they said was, Dearden kept going over to them in between witnesses at breaks and things like that and asking them how he was doing. Because they're all excellent lawyers. They are top tier lawyers. And he's like, hey, how am I doing? How am I doing? How did I do there? What did I do there? And I think they suggested it, or they said something in a way on purpose to make Dearden think, oh, I should have OJ try on those gloves, shouldn't I? And they were like, oh, no, don't do that. That would be terrible. No, 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 no. Even though they wanted him to do this. They wanted him to make OJ try on these gloves. And he fell right into their trap. And this is how it happened. They said in an interview later.
All right, let's have the jurors, please. And may I see Deputy McNair first, please?
I'm not fast forwarding it. I don't want to miss anything. I'm just waiting. It's a very pretty picture we're seeing. Do you know most Americans, all Americans, every single person in the world actually can't just sit quietly for a while and look at something like that?
Ladies and gentlemen, record to reflect, we've been rejoined by all the members of our jury panel. Mr. Dard, do you have any further questions, Mr. Rubin?
Just a few, Your Honor. Mr. Rubin, you said that 8% of the gloves sold, the extra large, brown in color, Aris leather lights would be
8% of the actual brown. Out of the 12 pair per pre-pack, one pair would be extra large.
okay. And so how many in 1990 then brown extra larges were sold?
300 totally available, possibly sold 200 to 240, depending upon conditions.
Okay.
That's huge, Anna. That's huge. That's a huge deal. That's awesome.
Your Honor, at this time, the people would ask that Mr. Simpson step forward and try on the glove recovered at Bundy as well as the glove recovered at Rockingham.
All right, do you want to do that? All right, you can do that seated there. All right. And I think so the jury can see, I'll ask Mr. Simpson to stand. All right. Mr. Darden, which glove do you have?
The Bundy glove, Your Honor.
All right.
And after Mr. Simpson tries on the gloves, I would ask that he be required to step back over to the jury and again show him his bare hands.
Well, we'll get to that in a second. All right, the record should reflect that, as is our practice with these gloves, Mr. Simpson will have a pair of latex gloves on while doing this.
I'm handing Mr. Simpson the left glove for Rockingham.
That's People 77. All right.
Assuming Mr. Simpson seems to have the problem placing the glove on his hand, could he be?
Sustained.
Also like to hand Mr. Simpson the other glove.
This is People's 164A. Is that the right-hand glove?
Yes, Your Honor.
All right. All right, Deputy Jax, would you just take a step back, please? Thank you.
They don't fit. He's pretending a bit, but they don't fit.
All right, record reflect that Mr. Simpson has both gloves. Yes.
And Mr. Simpson's indicating that his fingers are all the way into the glove, Your Honor.
All right. Thank you, counsel.
And Mr. Simpson told the jury that the glove was small.
All right.
Your Honor, before Mr. Simpson goes back, could we ask him to replace the left glove onto his hand?
All right.
Could we ask him to straighten his fingers and extend them into the glove as one normally might put a glove on?
Your Honor, I object to this statement by counsel.
All right. He appears to have pulled the gloves on, counsel. All right. Would you show that to the jury, Mr. Simpson, in that manner? Thank you. Other hand, please.
Can we ask him to make a fist with his left hand with the gloves on, Your Honor? Can we ask him to make a fist with his right hand with the gloves on?
He is doing both.
Can we ask him to grasp an object with his hand? Marker, perhaps.
All right. Mr. Simpson?
Can we ask him to grasp the marker with his hand like this?
I object to this, Your Honor.
Yes, I
Object.
agree.
Counsel,
Can
go
we
ahead.
ask him to completely grasp the marker with his hand?
Yes.
Right his waist or not?
Yes. All right. Thank you, counsel.
Thank you.
No longer an issue of cross-contamination, Your Honor. I have nothing further.
All right. Mr. Cochran?
I'm sorry, can we approach one moment before we, go on? Approach one moment?
Yes, with court reporter.
I know he had those gloves on underneath. I know that. I know that the gloves got wet because of the blood. I know that too. Those gloves did not fit him. Those gloves were not big enough for his hands. Let's just pretend for a second Those gloves do not fit him for real. For real, for real. Those gloves do not fit him. Then what does that mean? What just happened with this trial? Wow. Holy cow. I didn't expect it to go like that. I mean, I know I expected it to look like he tried to put him on, but he didn't really try to put him on. DNA. What do the DNA tests say? I'm trying to get my brain to make it so that the gloves that he had on underneath was like stopping the fingers from going down, and would have been different on bare skin. Look how smug he looks. No, no. It was all a big game, an act. Those gloves fit him. That's where I'm going. That's where my brain went.
Mr. Darden, would you wrap it up, please?
Your Honor,
All right, records reflect that Mr. Rubin has examined both Mr. Simpson's left and right hands. Mr. Darden.
Mr. Rubin, you sold thousands and thousands of leather gloves throughout the world, correct?
That's correct.
What size glove would you say would fit Mr. Simpson's hand?
Over. You can answer.
In some styles, size large, and most styles, extra large.
Should the gloves shown to you here in court today have fit Mr. Simpson's hand, in your opinion?
Over. You can answer the question.
At one point in time, those gloves would be actually, I think, large on Mr. Simpson's hand.
So you expected then that these gloves would have fit his hand here today, is that correct?
Sustain.
Well, the question is this. Would Mr. Simpson's hand fit into these gloves as they are today, in your opinion?
Sustain.
Should they be able to fit into these gloves?
Over.
His hand should be able to fit into that pair of gloves.
Okay. Now, would you expect that the fact that he's wearing latex gloves here today would that inhibit his ability to extend his hand through the gloves?
I personally have never put on latex gloves and tried on gloves, so I really couldn't say, but I would say that appears to be a factor. Because when he showed...
That's fine.
Okay.
Okay. Can you give the jury any explanation as to why Mr. Simpson couldn't fit his hand into the glove here today?
Sustain.
The manner in which Mr. Simpson put the gloves on today?
Yes, I did.
Okay. You've seen people put gloves on in the past.
Yes, I have.
Did he put the gloves on in a manner consistent with what you've seen other people?
Sustain. The jury observed what happened.
Anything unusual about the way Mr. Simpson put the gloves on based on your experience?
Sustain.
Could you tell whether or not he was intentionally holding his thumb in a certain position so he couldn't put the gloves on?
Sustain. Counsel, the
I have
jury
nothing further,
observed...
Your Honor. I have nothing further.
All right. Mr. Carter. Anything else? Certainly.
Small brains. What a disaster that was. That was a train wreck. That was a dumpster fire.
I'm mindful of the hour. I think we can finish. Mr. Rubin, did Eris Glove Lights make a size of glove called double XL?
Not prior to 1990.
And since 1990, have they made a double XL?
I understand they have.
And that's a extra, extra large, is that correct?
That's correct.
Now, with regard to the sizes of gloves, these gloves that were made back between the period 82 to 92 that we talked about, were they made so that each extra large was the same size as the next extra large? Or is there
That-
some variation in the sizes?
The intent was for them to be exactly the same. The patterns that were utilized were exactly the same size, but each few square feet of leather does have its own characteristics as far as stretchability.
So that one extra large might actually be smaller than another extra large. Is that a fair statement?
That's correct.
And there is that variability in the lots as they turned out. Is that right?
That is correct.
And you would expect that an extra, extra large would be larger than an extra large. Is that correct?
That's correct.
All right. Thank you very kindly, sir.
Darden? All right, Mr. Rubin, thank you very much, sir. You are excused. All right, ladies and gentlemen, we're going to take our recess for the evening. Please remember all my admonitions to you. Don't discuss this case amongst yourselves. Don't form any opinions about the case. Do not allow anybody to communicate with you.
Oh, they're breaking for the evening. The jurors are going to sit on this all night long. At least it's not a Friday, but it doesn't matter. We know the outcome. Oh, man. Oh, man.
Do not conduct any deliberations until the matter has been submitted to you. As far as the jury is concerned, we'll stand in recess until 9 a.m. tomorrow morning. All right?
Wow, what a day for the prosecution. Holy cow.
All right, back on the record in the Simpson matter. Defendants again present before the court with counsel, Mr. Cochran, Mr. Bailey, Mr. Thompson, and we have Ms. Hamburger here this morning for the witness, people represented by Ms. Clark, Mr. Darden, and Mr. Gordon. All right, good morning, Ms. Hamburger. How are you today?
Good morning, Your Honor. Maya Hamburger, representing Marguerite Thomas. Mrs. Thomas was scheduled for today, Your Honor, and Mr. Darden and I agreed to postpone her appearance until July 12th, with the court's permission.
All right. Then the previously issued body attachment will remain issued and held until Wednesday, July 12th, 9 a.m. Thank you, counsel.
Great. Thank you, Your Honor.
Oh, I'm shook right now, guys. I can't believe what I just saw. It, to me, really, really honestly looked like those gloves did not fit his hands. I know he had the gloves underneath. I know he was theatrically playing for the jury. I know this. I know that's his job. Man, oh man, though. Like, I saw how tight they were down here, and then he couldn't get his fingers the whole way in it, because they were... You would think, though, if it honestly didn't fit his hands, if you were going to put a pair of gloves on that did not fit your hands, actually, it wouldn't be the fingertips that would be empty. You know what I mean? It would be down here. It would be down here that the glove would, like, come up to the knuckle instead of going down to the bottom. You know what I mean? Does that make sense? Like, it wouldn't be the fingertips. If I was putting on a glove that was too tiny, it would, like, I would be able to put my fingers the whole way to the top. It's down here wouldn't make it the whole way to the bottom of my fingers. So he did the opposite. He was like, oh, it's too tiny. My fingers don't go the whole way to the end. And then it came up to, like, here. No, that's not how it would go. So, yeah, that was courtroom theatrics that were really, really freaking good. Elite level. Good job.
All right, Mr. Thompson, you have a matter?
Yes, Your Honor.
What is that?
Good morning. We need to briefly revisit the issue of the statistics to be presented in connection with the DNA mixtures. And earlier this week, the court directed the prosecution to let us know what their intentions were with regard to these statistics, and particularly whether they were intending to present likelihood ratio statistics, which are a novel form of statistical presentation on this matter. Late yesterday, Mr. Clark let us know that the prosecution does indeed intend to present likelihood ratio statistics, that they are intending to present them next Tuesday through their witness, Dr. Bruce Weir, and that the defense will not be given a final copy of Dr. Bruce Weir's report until late next Monday. This revelation raises three issues that I'd like to raise and discuss with the court at this point. First issue is whether the prosecution should be allowed to present novel, unprecedented forms of statistical evidence on mixtures at this juncture in the case, given the posture of the evidence and given the court's previous rulings on this subject. The second issue is the need for a 402 hearing in the event that the court entertains letting the prosecution establish the admissibility of this new kind of statistical evidence. We feel very strongly that a 402 hearing is required, and we need to discuss briefly the scope and parameters of such a hearing. And the third issue is the need by the defense for more time. The fact that we are getting the final report essentially the night before the prosecution intends to present this new evidence just simply does not give us enough time to prepare. We've received a preliminary report from Dr. Weir, but it does not include data or calculations. It makes citations. It says that its calculational approach is based on scientific articles which are not cited. They don't give us the citations to the articles. We've been unable to find them. And we will need, regardless of whether we have a 402 hearing or not, we'll need additional time to prepare, and we'd like a week. So those are the issues. I can take them in any order that you please.
You need to say more about them?
Well, I'm prepared now to give you an argument on the first point as to why we feel that the prosecution should simply be precluded from presenting this kind of evidence. We think we have no objection, Your Honor, to the presentation of aggregate statistics in the form recommended by the National Research Council, which we've discussed earlier in this case. It's a very simple form of statistical calculations which simply adds up the frequency of all the genotypes that would match with the mixture. We have no objections to that at all. We think it's simple, easy to understand. We have a series of very strong objections which we stated in our papers and in previous arguments. But basically, our position is that the effort to present a novel form of statistical analysis on the mixtures at this point should be precluded in light of the court's previous rulings and the posture of the evidence in this case. When the court ruled in May that the prosecution must present statistics on these mixtures, I think everybody contemplated that they would be frequency statistics, which are the same sorts of statistics presented on all the other DNA evidence.
Well, Mr. Thompson, let me perhaps give you insight into the court's thinking on this. And are you aware of any appellate case that addresses the admissibility of likelihood ratios in a criminal prosecution case anywhere in the United States?
None at all. As far as we
Only
can...
3 likelihood ratio cases in reported cases nationwide deal with likelihood ratios in fraternity cases, which is obviously not the situation we're dealing with here.
I agree completely.
Mixtures, et cetera, et cetera.
Yes. I mean, if I understand you correctly, you're saying you view this as an unprecedented matter. We do as well.
I think it goes from beyond novel to being unique.
Yes.
All right.
All right. So if I,
And I made a ruling back in June that I thought was pretty clear.
All right. So it sounds like your thinking coincides with ours, that the prosecution should simply be precluded from presenting statistics in the likelihood ratio form at this juncture.
Well, I think at the very minimum, if they insist on proceeding with that, I think we need a 402 hearing out of the presence of the jury.
All right. Well, let's proceed to that. In the event we have such a hearing, the defense would intend to call 1 and possibly 2 witnesses in order to explain why we feel statistics presented in that form are inappropriate as a scientific and statistical matter on the one hand, and on the other hand, why this form of statistical presentation is likely to be grossly misleading to the jury. I estimate we would need approximately 2 hours of expert testimony to establish those points.
Right.
But in order to prepare for such a hearing, we need more time than overnight after getting the final report, which shows what the prosecution is going to present. So
All right.
we'd like to put it off for a week if possible.
Thank you, Mr. Thompson. Ms. Clark, good morning.
We find ourselves in this unique posture because the defense has insisted on doing something that is scientifically unsound, and that is to apply frequency ratios to a mixture. That is not done in scientific circles. It is not an accepted scientific practice to assign numbers to blood-stained mixtures.
But isn't that what the NRC report recommends at page 69?
No, not as to mixtures. It doesn't. Yes, it says that we should assign frequencies to typed results, but I don't believe there's any place I've ever seen in the NRC report where it specifically says that mixtures should be reported with numbers. Then the problem is, if you want to do something scientifically unsound and to put a number to a mixture stain, then the most scientifically acceptable or accurate method of doing so is to assign it a likelihood ratio. We understand the court's concern because it is something unusual. The circumstances are themselves unusual.
You agree it's unique?
I do, absolutely.
Right.
And that's why we are more than happy to present Dr. Weir's testimony to the court. I think it's entirely appropriate. There's no question about that.
Well, counsel, what I indicated to Mr. Thompson is that if you feel that that's the way it needs to be presented, then I think what we're looking at is a 402 hearing.
And the people aren't arguing with that. The question is the timing, Your Honor.
Okay. Well, when will your expert be available? When is Dr. Weir available?
Wednesday. We had anticipated presenting his testimony on Wednesday, and so he is arranged to be here on that date. We all don't want to take the jury's time up.
I know, but we may have to, but seeing as how we avoided a 6 to 8 week Kelly Fry hearing, maybe a day or two out, we can take them to Disneyland or something. I'm sure we can find something for them to do.
Yeah.
All right, but my other concern, though, is I think that since this is a novel issue, because the court's research indicates that the likelihood ratios have not been presented in any criminal prosecution that I've been able to find, at least at the appellate level. There may be some on a trial court level, but I'm not aware of any at this point, but I'm willing to look and see.
Okay. Yeah. We will present to the court everything that we gather on this, and I'm
Right.
sure Dr. Weir is aware of where that has been presented before. in
The
this
issue is
context.
also timing, because I think the defense is entitled to see Dr. Weir's report and know what literature he is referring to, and then have reasonable time to prepare.
And of
So
course,
that's something that I would ask that Mr. Harmon and Mr. Thompson, while we're continuing with the glove evidence, confer as to availabilities of their witnesses, knowing that if the prosecution wants to present likelihood ratios, we'll probably need a 402 hearing.
okay.
And it sounds to me like half a day to a day, because
sounds
we're
right.
talking about statistical methodology is what we're talking
Right,
about.
that does sound right, Your Honor.
Okay.
Then the question I have is if we turn over the reports, and I understand we can do so Monday afternoon, if we present, the testimony on Wednesday for the 402, wouldn't that be sufficient time for the defense to read the reports and be ready to cross-examine Dr. Weir and present their testimony?
Could be.
Okay. We'll just wait
All
and
right,
see.
well, why don't let me have Mr. Thompson and Mr. Harmon consult, since they're both here today, and just find out schedules and who's available what days, and then we'll take it from there.
Okay.
All right, next issue is the defense motion for an evidentiary hearing. And Ms. Clark, you had left court yesterday, but Mr. Dershowitz was here, and given the conflicting schedules, it was his proposal that the defense be allowed to make their argument, which he estimated at 15 minutes or so today, allow you to hear the argument and then respond next week, as I understand that you're requesting.
At what time would they propose to do that?
Sometime today, sometime this morning.
This morning?
Yes.
Oh.
That was discussed with Mr. Dershowitz and Mr. Darden yesterday afternoon in chamber at the conclusion of the court date.
Well, if we recess in time, I can respond today, too. We were going to present a responsive declaration. I don't know if that's,
So let me ask Mr. Darden. Mr. Darden, how many more witnesses do you have this morning?
We'd like to recall Mr. Rubin back to the stand for a short while. Mr. Acosta is en route to testify. We'd like to call Ms. Redfern or Mr. Aguilera sometime this morning, time permitting.
All right, so you have enough witnesses to fill up the morning. Well, then I think we ought to hear the argument now. And proceed with the witnesses after we hear this, the argument on this motion.
okay.
All right.
Thank you, Your Honor. I'll try to keep the argument brief in light
Right.
of the...
I think Mr. Bailey wanted to say something to you.
To please the court, a little before 10 o'clock Central Daylight Time this morning, Officer Rodney Tilley of the Panama City Police Department approached Mary Ann Barbieri, the mother of Paula Barbieri, whose name has surfaced in this case. And as a messenger, allegedly for Detective Tom Lang, said, now that the relationship between Mr. Simpson and your daughter has changed, would you find out if she would like to talk to us? Ms. Barbieri has hired a lawyer, made it known to the prosecution that she can be reached through her lawyer and only that way. And we would like to make this a matter of record, because if it happens again, we will ask for sanctions. I am in touch with her on a regular basis. There is no change in the relationship. It is every bit as strong as it was on June 12th, 1994, and we would ask that she not be surreptitiously approached by the police. Thank you.
Thank you, counsel. All right.
Bailey, is Mrs. Gerchis a witness on your witness list? I'm sorry, Mrs. Barbieri. Is she a witness for the defense? I've never heard that name included as a witness for the defense.
She has not been included so far.
Okay. And we are familiar with Florida state law as it relates to witnesses and depositions in criminal cases, and we will act accordingly.
All right, but the contact with her is to be through her counsel if she's represented by counsel. All right, that goes without saying. All right, Mr. Dershowitz. Good morning.
Good morning. Thank you very much, Your Honor, for accommodating my schedule. I'll try to keep it very brief, knowing that the jury is out this morning. We are very concerned about the possible specter of a mistrial hanging over this very lengthy trial. The defendant, O.J. Simpson, has the right to have his case decided by this jury and not some subsequent jury. Yesterday's incidents and events make it as clear as any events could ever make it why the prosecution would benefit if they had a second opportunity to try this case. If the prosecution had a second opportunity, if they could do what, when we were kids, we called a do-over, obviously they would try this case rather differently. I doubt that we would see O.J. Simpson being asked to try on his gloves. I doubt that we would see Dennis Fong being called as a witness. That's precisely why the Double Jeopardy Clause, both under the United States Constitution and in its more expansive view under California law, gives the prosecution simply one shot, not another chance. And we are very concerned, because we're down to two alternate juries, that the prosecution, in one respect, has a no-lose scenario that they may be attempting, namely that they're trying to reshape the jury to its advantage by striking jurors selectively, and they know that the worst-case scenario is that there will be a mistrial, and if there's a mistrial, they get to try the case a second time. That's precisely what the Double Jeopardy Clause prevents the state from doing. Therefore, we, in an effort to prevent this from occurring, make two motions. One, that no further jurors be struck for any reason whatever, and that as part of that motion, at this point in time, as part of that motion, that once jurors are down to a number like 14, 13, 12 in the context of a case like this, that the standard of removing jurors is no longer good cause under California law. It rises to manifest necessity. That is, the Supreme Court of California, in a series of cases, Davis, Lariol, 1970 genre-era cases, made it very, very clear that there is a difference between the criteria for striking a single juror and striking a jury. And that when you get close to the line, that by striking a single juror, you may be requiring that a new jury come in, that the standard is elevated. The standard becomes not good cause, but manifest necessity. Indeed, several cases in the California Supreme Court make it clear that there are really three very different standards. One standard before jeopardy attaches for recusing a juror for cause, another standard while jeopardy has already attached for removing an individual juror when there is no likelihood that the removal of that individual juror may result in a mistrial, and a very different and highly elevated standard when the removal of a single juror or a series of jurors may result in a mistrial. And we think that this court should have, and should from now on certainly, be using a manifest necessity standard rather than a good cause standard for striking any jurors. And we suggest and propose and move that in the event there are any further jury problems, particularly problems of individual juror disqualification, that the court hold those in abeyance until such time as the case has reached its final point, the judge has instructed the jury, and the jury is going in to deliberate. At that point, either side could then move to have a juror removed for a good cause, and if the issue then certainly is simply the substitution of one to a good cause standard, rather than the manifest necessity standard. So that's the prophylactic motion that we're making, the preventive motion that we're making to assure that this jury decides this case, because statistically there is always the possibility that there could be death, there could be injury, there could be illness, there could be family problems that are beyond the control of the court. What's unique about this case, Your Honor, is that the 10 jurors that have disqualified up to now have not a single one, well, possibly one, but no more than one, has been disqualified for what would be the conventional reasons listed by the California Supreme Court as constituting good cause in the context of manifest necessity. They have not been traditional cases of illness or death or family problems. They have been more in the nature of juror misconduct problems, which we believe are issues of law. And the court has said that dismissal of jurors on issues of law or any mistake of law does not constitute manifest necessity. So that's step one of our motion. The second step is a rather more delicate one, and that is, Your Honor, we move that in the event this jury does not reach a verdict, for whatever reason, whether it be a hung jury or dismissed jury, or if it achieves a verdict of guilty, which we hope and pray it will not, that we ask now for a ruling that we can have an evidentiary hearing, which we would like to begin preparing for, at which we can summon the various personnel who have been involved in the disqualification and recusal of jurors. Because we believe that there is a basis on the record for our suspicion that the prosecution has targeted jurors, has selectively investigated jurors in an effort to shape the jury to its liking. And that, too, is not proper under the double jeopardy and due process clauses of the Constitution. And so we would like to know, in each case, for each juror that was removed, what the basis for the investigation was, who commenced the investigation, what the sources of the information were. We would also like to know whether there was information on the record about other jurors who the prosecution felt were to their liking, which was not brought to the attention of the court. Because as we argued early on in time, the structural problems of the way in which jurors are monitored in this jurisdiction create a real potential for prosecutorial abuse. We have no investigative resources. We don't have access to the sheriff's department. The sheriff's department is state action. It is law enforcement. We worry very much that the sheriff's department can be, consciously or unconsciously, a conduit to the prosecution of information about juror attitudes, a conduit of information about potential misconduct, which then can be selectively invoked. And if there has been any selective invocation of allegations of misconduct favorable to the prosecution, we think we're entitled to make a record on that and, if necessary, bring it to the attention of an appellate court. As Your Honor is aware, the issue of double jeopardy is an issue that can be presented to an appellate court on a writ of prohibition and can serve as a barrier to a subsequent trial because jeopardy has attached, and as the courts of California have said repeatedly, once jeopardy is attached, if a jury verdict is not reached, that is legally tantamount to an acquittal in the absence of consent by the defendant, which is not forthcoming, or manifest necessity, which we believe would not exist in this case if there were a mistrial caused by jurors being insufficient in number to render a verdict in this case. So, Your Honor, we ask for those two remedies. We have in the past asked for another remedy, namely, we believe, and we have believed from the very beginning, that the structural issue, namely the sheriff's department, law enforcement, state action of with a prosecutorial bent, being the people supervising the jury, being the conduit to Your Honor, being a conduit to the prosecution, raises structural problems. And we have believed from the very beginning that social workers, neutral officials of the court, not law enforcement personnel, should be the conduit, should be the people supervising the jury in this case. We renew that request. But the primary request that we're making here today, and I will simply finish with this, is the two that I've previously alluded to, a ruling that there be no further disqualification at this point in time of any jurors without a showing of manifest necessity, and such issues be put off until the end of the trial, and that in the event that there is less than a verdict of acquittal, other than a verdict of acquittal in this case, we ask for an evidentiary hearing to be held so that we can establish a record of juror targeting, that we can establish a record of how the prosecution may have taken advantage of the potential for abuse that exists in this system. If there are no further questions, Your Honor,
No.
I made my point. Thank you.
Thank you. Ms. Clark.
Thank you, Your Honor. Of all of the motions made by the defense, I find this one the most offensive, groundless, and baseless. This was a motion filed deliberately for inflammatory effect. It has no law in its support. It has no facts in its support. This is a scurrilous attempt to inflame the community, if not the very jury itself. It may be constitutionally protected speech, Your Honor, but constitutionally protected does not mean moral, does not mean ethical, and does not mean truthful. And the groundless, baseless, inflammatory allegations contained in this motion are the lowest tactics I've seen yet in this case. The defense knows precisely why each of the jurors were excused. They know precisely where the information came from. They know the procedure that has been imposed by this court in terms of juror investigation. And all investigations are conducted by this court, not by the prosecution and not by the defense. And Mr. Dershowitz does not know how the information came to light about juror 353. Why doesn't he talk to Mr. Cochran? Mr. Cochran brought out the anonymous letter sent to his office, the phone calls made to his office, because they were targeting juror 353 for months. We all know this.
There was no letter.
Mr. Cochran showed me the phone logs from his office, however.
Phone logs.
And Mr. Cochran, don't be disingenuous with the court. It's very clear that they wanted that juror excused for quite a long time. And for Mr. Dershowitz to stand before this court and make such allegations that the prosecution is targeting jurors is simply offensive and unethical and unsupported in any facts. And the defense posture, their very premise is absurd. That we would like to try this case again because we would try it differently. We would not call Mr. Fung. I would like for Mr. Dershowitz, a law professor, to explain to us how we could put on evidence without proving someone critical in the chain of custody. How do we present evidence without showing the jury how it came into the police custody? Mr. Fung collected it. Now, how do we present that evidence without calling him? If Mr. Dershowitz has an idea, I'd sure like to hear it. I heard no stipulation from the defense concerning chain of custody. I think it's our burden. Their premise is absurd. But I will offer Mr. Dershowitz one thing. I'd like to direct the court to the remark made by Mr. Dershowitz in which he stated that he thought we would try the case differently, and I quote, "I doubt that we would see O.J. Simpson being asked to try on his gloves. The people so stipulate. And if that's what the defense is offering in the context of this motion, we're glad to accept." Now, the premise is also ridiculous from a legal point of view. No further jurors be excused for any reason at all? Is that so? If Mr. Dershowitz were to know of a juror presently seated who said he's guilty and nobody's going to convince me otherwise, I've got my mind made up, where's his argument then? You think Mr. Dershowitz would stand before this court and say that very thing? Not on your life. It's legally absurd. There's no legal precedent for it. Not only that, but Mr. Dershowitz takes the concept of manifest necessity and stands it on its head. Manifest necessity has never been a standard employed in the context of juror excusals, Your Honor. Manifest necessity is used as a shield, not a sword. Manifest necessity permits a retrial where otherwise jeopardy would have attached, not the reverse. Mr. Dershowitz has the law standing on its head. And the case of Illinois versus Somerville, which discussed manifest necessity, discussed it in the context of a defective indictment, an indictment so defective that the charges could not be understood, the elements could not be understood. And so the case was set aside, although jeopardy had already attached, and manifest necessity was invoked to permit the retrial, where ordinarily it would not have been permitted. That's where manifest necessity belongs, not in the context of juror excusals. Mr. Dershowitz cannot point this court to any legal authority to justify invoking some new standard because we have some special defendant. There is a standard that applies to everyone, all defendants and all prosecutions in this state, and that is good cause. And this is not a different case, and this is not some special case. This is a murder trial where these jurors are going to be held to the same standard they are in every other trial. Good cause is our standard, and that's the standard we live by. And when a good cause is shown, as it was in each and every instance in this case, then they must be excused. And Mr. Simpson does not get some higher standard for the jurors he likes or doesn't like. Now, with respect to the jurors that were excused, at no time has the prosecution made any effort to seek out information as to any particular juror. In each and every instance, members of the public have come forward to this court or to the prosecution, and in the event that they've come to the prosecution, we have turned it over to the court. Many of the instances, the information came directly to the court and then had to be investigated. The court fulfilled its obligation as it's required to under the law, and as we're all very well aware, under Bergner and its progeny, when any indication of juror misconduct is brought to the attention of the court, it is obligated. It's mandatory language in those cases. I know the court is aware that you shall investigate. You cannot refrain from doing so. And it has only been when the misconduct has been so egregious that it was clear that the jurors could not be deemed to be fit jurors, either because of contradictory information in the questionnaire, based on what we later learned we learned that it was later proven not to be true, or because of conduct on this very jury. With respect to the excusal of juror 1489, several jurors came forward to this court to complain. That was not one person complaining. Counsel would have it seem that the prosecution is funneling information here and going out and digging up information on these people. Nothing could be further from the truth. And the court staff that the court has doing the investigation is nothing more than responsive, reactive. The deputies involved in the investigation are given information from the public and required to investigate it. So this motion is in derogation to reality. It's in derogation of the truth and of the facts. We have 10 jurors thus far excused, 5 at the behest of the defense. I think that probably speaks volumes right there. The court is aware of the procedures that it has imposed in this case, and to even entertain this thing that shouldn't even be dignified with the title of motion, I don't think I've ever seen law practiced this way. These are really baseless allegations. The declarations filed by Mr. Cochran have absolutely no merit, and they have no relevance. Brenda Postel makes some remark about some remarks made to her by some other deputy that has nothing to do with the allegations they're making. I eagerly awaited what was going to be in the declarations. When I finally saw it, I was shocked. There's nothing there. There's nothing there. So the court really has to ask itself, why is such a motion being made? Is it true that the defense really wants to avoid a mistrial? Is that true? I wonder. I really wonder. I think it's the defense that is looking for a mistrial in this case, Your Honor, and I think that this is nothing more than pointing fingers at anybody else to avoid the light of the suspicion that should be appropriately cast on this side of counsel table, on the defense side of counsel table. This is a baseless motion. This is a lawless motion. This is a factless, evidentiary-less motion. It should be not only denied, but I think that counsel should be admonished against making such deliberately inflammatory motions. It's irresponsible and it's unethical.
Thank you, counsel.
Your Honor, I'm new to this courtroom, but I will tell you right now, I am not, under any circumstances, ever, while I stand up here today, going to respond to any of the ad hominems. I simply am not going to play that game. I'm going to simply just talk to the merits of the issue. Having said that, I would urge the court to read the case of People versus Larios, which is direct support for our proposition that once the juror number gets down to the critical point where a mistrial may have to be declared, the legal criteria is manifest necessity, legal necessity. Let me read to the court one paragraph. The fact that a juror's actions or beliefs would provide good cause for his replacement if an alternate were available does not mean that this is legal necessity for a mistrial where no alternate is available. The Compton case as well certainly suggests the sliding standard, and the sliding standard makes enormous sense. If the court has the luxury of a large number of alternate jurors, then good cause is the standard. Unfortunately, that luxury no longer exists. And so we're at a point where manifest necessity must be the criterion. Let me respond directly to the question put. What if we were to find a juror that said, we believe O.J. Simpson is guilty in an unlikely event, I think after yesterday's proceedings, but if we were to find such a juror, it would be our choice and our choice alone whether or not to seek a mistrial. And that's what Larios says, precisely. If the judge were to impose a mistrial, if the prosecution were to seek a mistrial, at that point, jeopardy would attach. As the court said in a series of opinions, uniquely within the defendant's mind, and the defendant alone, is his tactical decision whether or not to risk a second trial, whether he has the resources for a second trial, whether he has the emotional wherewithal to sit through a second trial. And the United States Supreme Court and the California Supreme Court do not balance equally. The defendant is entitled to make these tactical decisions. The prosecution is not. This is not a level playing field under the Double Jeopardy Clause. The prosecution is not allowed to make tactical decisions preferring a second trial to a first one. The defendant is entitled to make precisely those very tactical decisions. Now, Ms. Clark talks about tactical decisions that she might make. She challenges the defense to ask how possibly this case could have been tried without the primary fact witness, Dennis Fong, being called. Well, we learned very well from the prosecution. Look at what they did with Dr. Golden. They figured out a way of getting around calling Dr. Golden, and they would try to figure out a way of getting around calling Dennis Fong. That's precisely why rehearsals are not permitted by the prosecution in criminal trials. On Broadway, plays open in New Haven and in Boston to see how they run. In courts of law, one time is all you get. The prosecution has had its time. May I formally correct the record when I referred to his gloves? Obviously, I was talking about the prosecution's theory that they are his gloves. The evidence yesterday proved dramatically that they are not his gloves. As far as our basis for this motion, the basis is very clear. If Your Honor didn't see, everybody else in the country saw Marsha Clark walking out after one of the jurors was disqualified, giving another prosecutor a thumbs up sign. We have an affidavit here that Mr. Darden told Mr. Cochran, we got your boy. We have evidence in the record that the LAPD is currently investigating for the prosecution jurors who are now sitting. The prosecution may deny that. That's why we have hearings. Precisely to resolve these kinds of disputes. If and when this case gets to an appellate court, Your Honor, they're not going to be able to take Marsha Clark's word on the fact that there were no investigations ongoing. They will want to see a record made. They will want to see witnesses sworn under oath. They will want to see evidentiary rulings, evidentiary conclusions. Deference will be obviously accorded to Your Honor's findings. We're aware of that. And we want a hearing at which we can call our witnesses. They can call their witnesses. We don't have to exchange ad hominems. The facts will prevail. If the facts go our way, we will win. If the facts go their way, they will win. That's why we have evidentiary hearings. Your Honor, excuse me one second. Well, I have to repeat what one of my co-counsel says. I was not here and I can't make this representation. But a very respected reporter said that Marsha Clark left the court after the juror was disqualified, quote, in a dance step. Now, I'm not sure the court wants to take judicial notice of the level of happiness the prosecution has expressed, but there is no question, and Your Honor, I'm at a disadvantage here because although I have read every word of all the sealed transcripts regarding the disqualification of every single juror, because they are sealed, I am not free to make arguments in public that I would make if we have an evidentiary hearing and on the basis of sealed records about the method by which jurors have been selectively disqualified in this case. And the fact that 5 may have been jurors who were favorably disposed according to the prosecution to the defense and 5, according to the prosecution, favorably disposed to them, does not enter into the double jeopardy considerations. Your Honor, I do have to acknowledge that this is in many respects a case of first impression. We have found no case anywhere in the United States where we've had a situation of 12 alternate jurors, 10 of whom are disqualified for reasons that are not traditional reasons, and then we get down to 2 with a potential for a mistrial. Courts have not had to consider, except the 2 cases that I've mentioned, the intimate relationship, the subtle relationship between good cause disqualification of individual jurors and manifest necessity as the criteria for avoiding the rigors of double jeopardy. But when Your Honor thinks about it, as a simple matter of common sense, and as I say, supported by Compton and supported by Larios, that sliding scale exists. And that if this court were, for example, God forbid, to get to a situation where it was down to the last juror, say it was down to 12 jurors, and there were to be then an issue of potential recusal of that juror, surely my distinguished opponent would acknowledge that at that point the criteria is not good cause. The criteria at that point is manifest necessity. That is the holding of Larios, not dictum. That is the holding of that case. And so, as a matter of simple logical extension, most of these cases deal, A, with short trials, B, in most of these cases, it's the defendant who's seeking the mistrial, and the prosecution who's seeking not to have a mistrial. When you have a situation relatively unique in American jurisprudence, a lengthy trial of this kind, 12 alternates, and then we get to a situation where nonetheless we may have a mistrial over the strong objection of the defendant, manifest necessity becomes the constitutional criteria, both as a matter of California law and as a matter of federal constitutional law. And in order to determine manifest necessity, we have to know on the record what happened. And we don't have a full enough record at this point. I will concede and acknowledge and assert that my opponent is correct. At this point in time, we don't know everything that happened. That's precisely why we're seeking a hearing. We are not calling our opponent's names. We are simply seeking a hearing. And that's the way I would like the record to remain. We are respectfully seeking an evidentiary hearing at which we can call our witnesses in order to establish that if this jury gets below 12, it will not have been the result of manifest necessity. If that is true, double jeopardy applies. Mr. Simpson is deemed innocent, and he cannot be retried again. Thank you, Your Honor.
Thank you, counsel.
I have one moment with my counsel before I conclude. Right, just one further point. We do not want our silence to be taken as an acknowledgement in reference to Juror 353 that Ms. Clark's characterization of the grounds upon which that disqualification occurred is true. We dispute that. We, because the record has been sealed, are not right now in a position to publicly dispute that, but we will file a sealed statement as to what our position is on 353, 1427, and 1489. We have very strong views about the relationship between the disqualification of those three jurors and why the disqualification of 1489 was not an appropriate disqualification, not under good cause, not under manifest necessity. We need not litigate that at this time, but we do not want our silence in any way to be taken as an acknowledgement that we accept the characterizations of Ms. Clark. Thank you very much, Your Honor.
All right, thank you, counsel. Very.
People versus Larios has been miscited by counsel and mischaracterized by counsel. People versus Larios measures the entire proceeding, not any single excusal. It looks through the entire record to determine whether or not good cause was established for the excusal of the jurors in general, with respect to each and every one, and then overall, whether there was manifest necessity for the risk trial. And that is where Larios stands. Larios at no point says that manifest necessity is the standard by which each individual juror must be excused. And Larios goes to actually to a separate issue, which is whether a mistrial should or should not be declared. And in that vein, counsel is also incorrect. Counsel cites to the court the fact that only the defense can choose to provoke or choose to have a mistrial. It is true that only the defense can make the motion for a mistrial. However, the defense cannot declare the mistrial. The defense cannot determine or provoke the mistrial. And there are cases right on point that state that even where the defense creates a ruckus in the courtroom, where the defendant has attacked his lawyer in the courtroom or attacked a witness in the courtroom, with the deliberate point being to provoke a mistrial, that the court is within its discretion to refuse to give them the benefit of their misconduct. That is within the court's discretion to declare the mistrial. The court decides when a mistrial should be granted. We have not reached a point yet where we have to make a decision whether we should proceed with fewer than 12. But I can tell this court that it will be certainly my position that we should. I have no desire to see this case go to retrial. I have no desire to see this case go through a mistrial. I want a verdict out of this jury. And I know that I speak on behalf of all of my colleagues on the prosecution. We want this jury to reach a verdict. That's what we want. And if that means that at some point we have to decide to accept fewer than 12, we will make that decision at that time. But with a very strong leaning in favor of going along with that, because that is not what we want. Mr. Dershowitz, in the course of saying we aren't going to call our opponents' names, does that very thing. I love that kind of disingenuous stuff. Let's be honest, that's what he's doing. And he's going to cite a reporter's hyperbole. I mean, that I did some dance step, that's nonsense. But look, reporters have to sell stories. They're good writers. It's fun to read, some of them. All right, I see the court's rolling his eyes. That doesn't apply to all, but some are. Some really are. I enjoy reading them. They have to sell copy. It sounds a lot more exciting to hear that the prosecution's out there dancing than it does to say Ms. Clark walked out and seemed to have a smile on her face. Oh boy, that's real fun. So that means they're going to write something that's going to grab people's attention. And we're going to cite that to the court as a basis for saying that the prosecution is targeting jurors? That's fine. Let me also then add to the record Mr. Cochran's beaming face laughter and laughter at the excusal of juror number 353. Let me also add to the record Mr. Cochran's negative remarks about the few remaining white jurors on this panel. No, Mr. Cochran really cannot afford to resent that with what he put in his declaration.
Wait. Mr. Cochran, have a seat. I'll deal with this. I don't think that's necessary, Ms. Clark.
Then let me just address it in the context of the motion, Your Honor. Mr. Cochran put into his motion a declaration.
I don't think you could ever honestly believe that I would ever consider extrajudicial commentary, newspapers, as sources of information that would cause this court to take any action, at least in this context.
Then I will not mention that again.
All right.
I was referring to Mr. Cochran's declaration, in which he cites an offhand remark made privately in jest between Mr. Darden and Mr. Cochran as a basis. That alone, that declaration alone tells you that there is no merit, there is no substance to these allegations. But the court is in possession of all of the facts. The court knows, as the defense knows too. Mr. Dershowitz perhaps himself doesn't know, but the rest of his team is very well aware of how the information came to light in this case. They're very well aware of who reported what transpired in chambers, what the court's rulings were, what the investigations turned up. They know that. That's what makes this motion so hollow, so empty. And none of the cases cited by counsel is at all on point or should cause the court to alter a standard that's been in place in California for many, many years. The bottom line of this motion is that it's okay when you excuse jurors we don't like, but we don't want you to excuse the jurors that we do like. That's what this motion is about by the defense. You can only excuse jurors when we say it's okay. Obviously, that's not the standard. There's nothing legal about that. There's no precedent for it, and there's no logic to it. And that's basically where this motion stands.
Thank you, counsel.
Your Honor, just 1 second, please. I know Your Honor will read the Laros decision. I can't believe that Ms. Clark was actually citing that case because that case involved one juror, not many jurors, and the court made exactly the statement that I said it made about one juror when that one juror becomes the critical juror. So the law in California, Your Honor, is clearly on our side. This is not a case where the issue is shaping jurors by the defense. This is a case where the defense, before the last 3 jurors were disqualified, filed a motion making precisely the same point. All we've done now is elaborate on that motion, including what was done since that period of time. So our motion was made even before the last 3 jurors were disqualified. We were concerned about this from the very earliest point in time. Our concern has only been enhanced, and we will provide this court, as I said, with a sealed argument regarding the last 3 jurors, which we think support our position. Thank you very much, Your Honor.
Thank you, counsel. It's a fascinating situation where starting a trial with 12 alternates, I mean, that's something highly unusual, even in this courthouse. I spoke to Judge Pounders the other day, who tried the 2.5-year McMartin case, and he tried that case with 6 alternates. And I was criticized by some of my colleagues for having started this case with 12 alternates, for having too many people, and that it would increase the cost of sequestration enormously, which was fascinating in and of itself, that discussion. But I've never seen a situation where individual jurors have been the subjects of such great public scrutiny. And that's one of the interesting aspects of this case that we'll have to think about when this case is all over. All right, counsel, I'm going to take your motion under submission. I'll read the declarations that have yet to be filed, and I'll issue a ruling as soon as that has been completed. All right. Let's have the jurors. Oh, I'm sorry. There's one other matter.
No, there's not.
Mr.
No,
Darden, you indicated you wish to reopen with Mr. Rubin?
not Mr. Darden. No, sir. That's a for tomorrow type deal, Judge. Judge, we've gone through a lot today. I'm still floored, completely blown away about what I just saw in this courtroom today. I knew it was big, but I did not think it was that big. I did not think I would feel this differently. Not about OJ. Just about the way the jurors think. How all the strong evidence, the DNA, the blood at the crime scene, in his Bronco, at the house, on his clothes, on his socks, the hairs in his cap from Ron and Nicole, those were all solid pieces of evidence that no one knows about because it was so freaking long and so freaking boring and so bad. I don't even know if anybody ever even said. So, was OJ's blood found on those socks? Yes. Was Nicole's blood found on those socks? Yes. You know, it was just so... But the glove That was right there in our faces. There wasn't a whole bunch of talking. That was shown right there. So, oh well. I'm going to get ready for work. You guys have a great day. Thank you so much for coming out. I am going to cut the glove part up into a video and post it later. I hope you guys have a great day. Bye, guys.